Thanks, Steve. And just by way of background, Steve is one of the top counsels for venue operators in the country. So if anyone needs help on that from an entertainment and a sports perspective, quick background on me. I do have one large entertainment client where I do deal with some of the same issues that Steve does. I represent the operator of numerous music festivals, including I'm general counsel of the Pitchfork Music Festival in Chicago. My sports practice does cover a full range, short of agency work, so I'm not going to interfere with any agents. But some of what we talk about has to deal with, from a sports lawyer's perspective, the problems you can get into if you are an agent and a lawyer, and at what point do the professional rules of responsibility as a lawyer affect you as an agent, because being an agent doesn't mean you have to be a lawyer all the time. So just and here's the thing, I'm sure many of you have sat in on CLE before. I probably sit in and I teach as well, so 200 hours maybe, and ethical presentations generally tend to be, I want to hang myself. This is the absolute worst thing ever. Please get me out of here as fast as possible. So we try to lighten it up a little bit. So just some slides on historical perspective of modern sport. Idea is that you're supposed to be ethical as going through it, as Steve showed in the first slide. Now what do we have? We have steroids, we have HGH, we have inappropriate levels of testosterone, epitestosterone, and a guy just wants to go to the ballpark and watch a game. Again, drugs and steroid use. We have the Bay Area Laboratory Collective. We have our friends in cycling. We have great mustaches. Money. I don't know if my friend Steve Webb is here yet. So obviously there's this idea of amateurism that the NCAA upholds. The Olympics seem to have given up on it. But that money should not be something that goes into our players at a certain level that we should enjoy just for the game. Obviously, we see it coming more and more earlier and earlier. And then gambling, ethical issues that go along with that. Obviously, it might not be obvious, but maybe you guys don't know, you cannot hold an NCAA championship in the state of Nevada because they do allow gambling on sports. Sex scandals, of course, as someone who teaches law school, the amount of slides that I have on Tiger Woods probably exceeds the amount of slides I have on antitrust issues. It just makes for more interesting cases. Criminal behavior, that is Andre the Giant, in case anyone was wondering. Officiating scandals, anything from figure skating to the NBA. Faking injuries, not really an ethical legal issue, but just something where we can go and dump on players a little bit. As lawyers, it's fun to do. So, Mr. Calhoun, as us at Boston College call Connecticut SUCON, he says we may have broken rules, but we did not cheat. Does anyone want to tell me what the difference is between breaking rules and cheating? Isn't the definition of cheating to break rules? And I think what you see here is lines that people make in ethical dilemmas, right? We had it out of Slick Willie as our president, right? I did not have sexual relations with that woman. Now, he's a lawyer, and I believe he was censured by his bar association. What state? Arkansas. So, different states and different state bar associations are going to treat different ethical transgressions differently, right? So, here we have a basketball coach knowing full well what NCAA rules are, and knowing the line, stepping over that line and crossing that line, and then getting caught and saying, well, I broke rules. But it's not cheating. Who thinks it was cheating what Belichick and the Patriots did? Who can tell me what it was that they did? Yeah?
Secretly videotaping practices of their upcoming opponents. signals, plays, things like that.
And how are they using that to their advantage?
They would know what the signals were for a given play call, so they would alter their offense or defense better.
Providing a competitive advantage.
Right.
Okay. Do you think there should have been punishment meted as a result?
Absolutely.
Okay. And why is that?
It's not within the spirit of the game. It's like you said, competitive advantage. You know what play the other team is going to run.
So I'm going to stick with something you said. Competitive advantage, right? As lawyers, as sports lawyers, as entertainment lawyers, is it possible to have a competitive advantage over another lawyer? You're shaking your head. How so?
I'm just an observer here, but yeah, inside, if you were at a party last night and somebody said something that you now know that the owner, Robert Server, is going to make a pitch to someone, I don't know, the Warriors, I can go to them, to the Lakers, to my favorite game team, and say, hey, Robert Server is going to bid on that player. He's going to want to draft that player. He's going to draft that player number 1.
Okay, so that seems to be something in the same vein of insider trading if you're a broker, right? You could get competitive advantage over another lawyer maybe from paying a client of somebody else, right? Enticing them to come with you. We know from the discussion that we just had here that you're not supposed to do that, right? You should be pulling in clients based on your own legal acumen and legal wherewithal, and not bribing, okay? So if you believe Coach Calhoun, you would say, the line's murky. You know, it's a dotted line. It's not a clear line. I don't know exactly where it is, so I can hopscotch across it. And what you'll see at every level, from AYSO soccer, I've contemplated litigation, by the way, at the youth soccer level. That's some of the stuff that you see. Having drafts between fourth graders in soccer, coaches rigging drafts. Okay? Litigation. It was on the table. So you will, even at the lowest levels, see people pushing boundaries. See people seeing how far they can get to be able to gain a competitive advantage. Here's the problem. If you are a licensed attorney, rules of professional responsibility will always apply, even when dealing with administrative bodies like the NCAA. So even if you are in a proceeding that does not require you to be licensed, that does not require you to have a law degree, you are always bound by those rules of professional responsibility if you do have a JD and you are licensed. So when you see these numbers, these are actual rules, okay? These are model rules of professional conduct that every state, every bar has adopted. So when we talk about Model Rule 1.7, we talk about conflicts of interest. 1.13, organization as client. 1.6, confidentiality. 2.1, advisor. If you guys, after you take your character and fitness exam and you go through the rules of professional responsibility, in Arizona, do you guys are you required to take a professional responsibility course here at Arizona State? So you tend to forget it. You know, you cram it, you get all these rules in there, and a lot of it seems intuitive, and you take the test and you move on. But that's not just it. You consistently will run into these situations on a daily basis as a practitioner. Now, I don't have it listed on this slide, but who can tell me what the number one ethical violation is for lawyers? What's the thing they get in trouble for most? Anyone know? Yeah. Anyone? Hands? Yeah.
Not returning calls to their clients here.
Okay. I mean, that's something that you'll see complaints to bar associations for. But what's something that they actually get in trouble for? What's a malfeasance that they get in trouble for? Commingling of funds. Okay? So you take in money and you then use it for your own personal gain, potentially, or usually the situation is, all right, my client gave me a $10,000 retainer, and I'm a little behind on my mortgage right now. I'm going to pay it back, but I'm just going to pull out from that fund that I have right now. Or you take client use funds and mix it in with your general funds to be able to pay your secretary. It's very common, lawyers still do it because it's cash right there, and they're going to pay it back eventually, right? But you can't do that. Other considerations. What's your scope of representation? This is something we talk about guys who are agents as well as attorneys. When are you serving as the agent? When are you serving as the attorney? And what's the difference? Well, the difference can be sometimes, have you gotten that client from an agent perspective thinking that what you're bringing to the table for them, for marketing deals, for financial deals, that Esquire that is at the back of your name, every time that you put together a deal that does not require your legal acumen, you need to be clear with that client, listen, there's a separation here between my law practice and my agency practice. That comes in a very unique way on Model Rule 5.5. Because oftentimes when you're an agent, you're going to be in multiple states, right? So say you're based in Los Angeles and you go with your client to an event in Vegas, right? Someone in the crew, your client, gets caught smoking a joint on the casino floor. You got to go bail him out. Do you go get a local attorney in Nevada who's licensed in Nevada? Or do you go down to the lockup, say, I'm a lawyer, that's my client, I got to get him out? You can get in trouble. So just be careful. Make sure you get local counsel if it's needed. So competition with non-attorneys. Again, competitive advantage. Be careful if you're using the ESQ at the end of your name as a competitive advantage over someone who does not have that law degree. Because you are going to be bound by the professional rules of responsibility, and that non-attorney agent is not going to be bound by those same rules. So be careful in attempting to compete with that non-attorney, because they may be able to get away with certain things that could wind up, for you, having you lose your law license, get it suspended. Again, we talked about that, wearing two hats. Two cases, these are pretty good opinions. All of an attorney's legal and non-legal services are considered to be legal services for purposes of determining whether a lawyer must comply with the rules. Another situation actually cited by the California opinion came from my home state of Illinois. A law school graduate who handled player representation and practiced law from the same office is also practicing law in his role as player representative. So who cares? What does that mean? Again, I cannot stress it enough. You will be bound by the rules of professional conduct. You might not be breaking the law. You might be following the rules of whatever players' associations certify you. But you might be breaking rules of professional responsibility, and you could have your law license suspended or revoked. We talked about this, commingling of funds, conflict of interest. Advertising is a place that you really need to be careful. Advertising, marketing from someone who wants to be an attorney and a financial guy, an attorney and someone who's involved in real estate transactions but not as an attorney. Maybe there's two separate companies, you got two separate business cards. Be careful when you're marketing services that are not on the legal end, and then you decide, well, I got this client in because we're partners on a real estate deal from a financial perspective, and I'm just going to do the legal on that. And I'll tell them, you know what, just pay my bill on that. You know, I'm not going to send off to someone else. I'll give you a better deal. I'll just do the legal end of that. Make sure it's fully disclosed to that client that you do not have a relationship between your non-legal business and your legal business. Make it very clear to that client because you can get in big trouble. And also, a lot of you, if you're practicing law, one thing we always forget about is malpractice insurance, right? What do insurance companies not like doing? Paying, right? They don't like paying. Otherwise, they wouldn't be called insurance companies, right? They would just be called ATMs. They look for reasons to turn you down. If you get charged on malpractice, if it is found that it was some type of practice not linked to your law practice and you are found liable, you might not have insurance coverage. They might be going after your former client, assuming who's suing you, might be going after your personal assets. Okay? Just keep that in mind. So, what are the solutions? Relax ethical standards? Not likely. Maybe require all agents be attorneys? Possible, not likely. Stronger regulation of non-attorney agents? We're seeing some of that come up now. And better guidelines from state bar associations. Now, I have one quick story before I turn it over. Ethical situation, which isn't on the slides, which I've forgotten about. So one of the sets of clients that I have from a sports perspective is sports and recreation. So one of my buddies in Colorado represents ski resorts. I do some things that are closer to what we have in Illinois, Wisconsin. I might represent an outfitter that rents out kayaks, things like that. It's just, it's fun. I get a kick out of it. It's not a big moneymaker, but it's interesting stuff, all right? It's real sports law stuff. You deal with sports and recreation law statutes. So I had a guy sue my client, and the plaintiff was someone who was hurt utilizing the services of the outfitter. Liability is clear. We go into mediation because we don't agree on what the dollar amounts are ahead of time. We want to limit legal costs. Clients pay me out of pocket. There's not insurance monies that are paying me. And we get into mediation. We're sitting in there. We go through it. Whatever. Pay out. It's fine. It was good resolution. Both people walked away happy. Fine. 2 weeks later, trying to figure out whose name has to go on that check. Whose tax ID number goes on that check. And the plaintiff's attorney says, just put my name on the check. You don't need to put my client's name on the check. What are you, insane? I'm going to put your client's name on the check. I'm going to be responsible for that, just handing you money. This money is for you and for your client, for your fee and for your client to get recovery. Week later, yeah, just put my, don't worry about my client. Put my client's wife's name on that check along with mine. What is wrong with this guy? No, man, come on. Find out that the plaintiff actually died 2 days before the mediation. Never told us that his client had died. So I was under obligation to report that other attorney. By the way, if you are aware of a violation in every state, you're obligated to report it. So it's kind of like an honor code among attorneys. So he was suspended as a result, and I found out that during his suspension, his two-person law shop that was entirely in his name, on the website, he went from being owner and partner to senior law clerk, and his first-year associate was head trial attorney. So I'm not sure if he abided by the suspension, but just to give you an idea. All right, thanks. I'm going to turn it over.